Greetings, everyone, and good afternoon.
Hello, Mr. Soto.
Thank you, Mr. Krupenbacher. Now I know that everyone can hear me. I'm going to call this meeting to order, and I am going to introduce, prior to starting off our agenda, I will introduce Board Member Tim Weisire to present an invocation, after which I will ask our Superintendent, Dr. Pace, to recite the pledge for us, and um, then Ms. Terry Castillo, if she would please present our mission statement. So I will hand it over to Board Member Tim Weiseye for the invocation.
Can you guys hear me?
Mm-hmm. Yeah, now we can hear you.
Okay,
yes.
now I can hear too. So we're on?
Yes.
I'm supposed to be praying, I take it. Okay, got it. Well, good evening, all. All right, let's pray. God, as always, it is our pleasure to come before you as our God, our creator, and the one that we can lean to in times of need and times of great opportunity. And we pray for our families across Osceola County tonight. There are many that are concerned, many that are scared, and many that are overwhelmed. But we know that you are still the Prince of Peace that's able to meet us in our time of need, to provide what we need as individuals. We thank you that we live in a country. We have the honor to come together as a board to make decisions in the best interest of our community. I'm grateful that I serve with a board, a superintendent, and a team that always thinks of what's in the best interest of our students, our families, and our community first. We pray, as always, for your wisdom tonight, that we would always make decisions that honor and serve you first, and that recognize the unique needs of each of our individual students across this community. We once again thank you for the frontline workers that are making a difference every single day to deal with this pandemic and to find cures and to be alongside the bedside of those that are ill. We thank you for leaders that choose to serve, and we ask that we would honor you tonight. It's in Christ's name that I pray. Amen.
Thank you, Mr. Weisire. At this time, Dr. Pace, if you would allow me, I would like to invite Terry to recite the pledge for us.
Please, sir.
Ms. Castillo.
Thank you for giving me the honors. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you, Ms. Castillo. And Dr. Pace, if you would grace us with the mission statement, please.
Education which inspires all to their highest potential as responsible, productive citizens.
Thank you, ma'am. Board, I'm going to call just in the order of districts for any kind of positive comments. I will start with our District 1 representative, Terry Castillo.
Nothing much, just incredibly proud of the work that our educators are doing out in the field and ensuring that our kids are still in school. School is still in session. Thank you.
Thank you, ma'am. As District 2, I would like to also commend the hard work that our educators and our parents are doing. It's quite interesting that these horrible circumstances have somehow forced this very strong collaboration between our educators and our parents. And I believe that probably there's a lot of learning going on from the perspectives of public education of students, one party learning about the other's perspective. And I just see so many positive things coming out from learning and appreciating this new, literally, stepping in and sharing, into the shoes of someone else. And I just, no, that was about it. I'm very interested in seeing how this further develops. So with that, I'll go ahead and call for our District 3 representative, Tim Weisire.
Thank you, Chairman. The only comment I want to make tonight is just again expressing gratitude for our staff all across this district. I know that we're dealing with challenges every day, and implementing distance learning and overseeing it and engaging your students and families and adapting to the times that we're in. I know that it brings a whole new level of stress and challenge to the work. But I don't want to miss the opportunity, again, to whatever department this may reach, is that the work that you're doing does make a difference and it is meaningful. And I know I speak for the entire board when I say that we appreciate you and we value the work that you're doing and the fact that you've chosen a career that directly impacts the lives of students. And as we've said all the way along, school is still in session. Learning may look different and take place a little bit differently, but the importance of students still learning and growing is taking place every day. And I want to extend personal gratitude and thanks to all those that are making sure that that's happening at all levels in every department. Thank you.
Thank you, Mr. Weisire. I would then call on our District 4 representative, Mr. Clarence Thacker.
I'd just like to add on to what everybody else has just said, particularly our teachers, to thank them for all they're doing. Way of learning. Thank the parents and students being in there with us. We know it's hard. We know it's difficult. But everybody's trying to do the best they can right now. It's a tough situation, and we all just have to get through it together. So I thank you for what everybody's doing, and thank you for your patience, and appreciate everybody out there, what they're trying to do to take care of themselves, their families, and get themselves or their children educated, or their students. Thank you.
Thank you, Mr. Thacker. And finally, our District 5 representative, Mr. Ricky Booth.
Thank you, Mr. Chairman. I don't have much to add. I think you guys summed it up very well. But certainly, I was going to say thanks to the parents, and thank you to the students for working hard. We know it's different. We know it's difficult to be stuck at home. We understand. I have 3 of my own, and so I understand. But keep working hard. Do the best you can. Don't get stressed out, and let's keep moving. Not just Osceola County forward, but the state of Florida and our nation, and we'll get through this together. So.
Those are very encouraging words. Thank you, Mr. Booth. And that concludes the positive comments section of our agenda. And at this time, I'll call on the superintendent, Dr. Page, for the approval of administrative transfers.
Thank you, Chairman Soto and members of the board. We do have 3 administrative transfers that I'll bring forward to you in one recommendation tonight. Again, this goes back to taking advantage of the strengths and skills that we have of our people on our team, and also helping them to find a place where they can continue to serve at high levels as we continue to work to move the district forward. First on the list is Miss Andrea Juergens. Miss Juergens is currently the assistant principal at Horizon Middle School, and I'm very pleased to recommend her to become our coordinator of K-12 mathematics. Sadly, we are losing Tammy Deary. However, I am confident that Miss Juergens will be able to step forward and continue the great work that Miss Deary has done to help strengthen math instruction across the board. That would be effective May 4th, 2020. I also am bringing forward in this same recommendation, item 2.01, the transfer of Mr. Keith Anacata, currently the assistant principal at New Beginnings, to become an assistant principal at Horizon Middle School, to again allow Mr. Anacata to continue to learn and grow and also serve the district in an effective position. That would be effective 6/1. And then in an effort to help continue our succession planning and build strength across the district, I'm pleased to bring forward under 2.01 a recommendation for Ms. Georgette Paulsen, currently assistant principal at Gateway High School, to become the assistant principal at New Beginnings, again effective June 1, 2020. And that concludes the administrative recommendations for transfers tonight under 2.01.
Motion to approve.
Second.
All right, so we have on the floor a motion to approve by Mr. Weishire, a second by Ms. Castillo. Is there any questions or comments before we take a vote? Pausing, I see no hands, therefore I call for the vote. All those in favor, please state aye. Aye. And I believe I registered 5, therefore the vote passes 5-0. The next item on our agenda is an opportunity for the public to offer comments to the school board. We have invited those comments through our email or through a text to a phone number 407-228-7330. And Dr. Pace or Mr. Krupenbacher, can you just volunteer a little bit of how this process and what we've done to make it so that our public comments are going to be heard and addressed?
Yes, Chairman Soto, based on our previous conversation and in consultation with Mr. Kreppenbacher, I will read into the record board comments for the 3-minute period of public comment that would typically be allowed. Any remaining information in the public comment would be added to the board record. And of course, the entire comment will be added there as well. We do have 6 public comments tonight. 3 are fairly general, and then 3 are specifically related to items in the agenda, on the agenda. So with your permission, Chair, I will read the more general public comments now into the record, and then we would handle the other 3 that are related to specific items on the agenda at the time that those come forward.
Very well.
Okay, starting, we have a comment from Jeffrey Pena Guzman at 2711 Uxbridge Lane in Kissimmee, Florida, 34743. Dear Osceola School District, thank you for all that you do in this great, amazing county called Osceola. When I think about the Osceola School District, I'm reminded of the great programs that you all have in science, technology, engineering, arts, and math. These programs will allow our future students to have the necessary skills that they will need to both survive and thrive in this economy. Now, I know that these past several weeks have been difficult for so many people, including me and you. Nevertheless, I am very grateful that you are still doing your best to provide the great students of Osceola County with a high-quality education. For that, I say thank you. Also, one of my siblings is a student at Parkway Middle, and I am very happy for the positive impact that her teachers have had in her life. Moving forward, I would like to ask that you continue to keep up the great and excellent work to prepare students for life beyond high school. Also, make sure that you are providing a high-quality education to students with disabilities, English language learners, and ESE students. Remember that these students are also important to the success of the school district. Finally, there is no doubt in my mind that this is the best school district in the state of Florida. Thank you and good night.
Thank you, Dr. Pace.
Second public comment comes from Cheryl Lee Rosario. Hi, I would like to know what's going to happen with the 9-month employees like me, substitute assistant cafeteria. Did we going to still get paid for this week's reminders? We have to go in made to work. I would like more information. Thanks, Cheryl Lee Rosario. And then finally, Chairman Soto, this item is related to item 10.04 on the agenda, but because I believe this will come up during agenda modifications, I'll read it now. It says, my question to the school board members, are you in receipt of our objection letter to the Victory School K-5 and K-8 approval for charter that was sent to each of the board members yesterday and also to the Inspector General of the state of Florida? A letter was also sent by our attorney to the legal counsel of the school board. Thank you, Mark S. Urali, Chief Financial Officer, usconstructioncorp.com. And that concludes the public comment of a generic nature, sir.
Thank you, Dr. Pace. Board, do you want to address any of those comments? I'm just pausing to see hands. Seeing none, that takes us to the next section of our agenda, which is modifications. I'll start from, again, District 1, Terry Castillo. Do you have any proposals?
I do not have any agenda modifications. I think anything that I want to be taken out might be taken out by somebody else. 10.4, are we getting rid of that? Okay, yeah. I was going to suggest that we take out 10.4, and I think there's others that might be in agreement with that as well.
Mr. Chairman, I believe it's already not part of the consent agenda.
So I think that allow me to try and lessen the confusion here and just call on Dr. Page. What are the agenda modifications that we know that we need to take? And then if there's any board member that needs to add to that, I'll go by hand.
Yes, sir. And again, Chairman Soto and members of the board, I apologize. We do not like to have to change the agenda, but a couple of things have come up. First of all, I would like to pull items 9.01, the gifted add-on program. We will be bringing that back as a consent item on the May 7th board agenda. It was mistakenly placed under presentations or information. I also would ask that we pull item 10.04, the application for the Victory Charter K-5 in reference to letters that we received yesterday that I have already shared with each of you individually. In addition, we do have 2 items that we are asking to blue sheet for this particular evening's agenda due to the sensitive nature of timing for those. Number 1 would be item 12.07, approval of the guaranteed maximum price amendment number 1 with Wharton Smith for the Poinciana High School campus-wide lighting upgrade project in the amount of $1.8 million. And also item 13.01 under regular school operations, approval of the emergency summer food service program agreement with 4R Restaurant Group LLC, which would allow us to add an additional feeding site to serve our students in our community in the coming weeks. Those are all the modifications that I have, sir.
Thank you, Dr. Mason. That makes everything so much clearer. I am going
Chairman, Mr. Chairman,
Yes.
may I just point out one thing for the benefit of the board? When you get to item 1101, 02, 03, and 04, the board will vote on 1101 as the school board. The chairman will then recess the board meeting and adjourn the leasing corporation meeting for the votes on 02, 03, and 04. He'll then adjourn the leasing corp and then reconvene this board meeting. That's it, Mr. Chairman.
Sounds good. Look, I did want to thank you, Mr.
Meeting within
I'm looking for hands for further modifications, but I do see Mr. Thacker. Mr. Thacker, the floor is yours.
Actually, I didn't have a modification. I just got a little confused. There were some other public comments. Normally we do public comments all at one portion. Are we now moving those to the agenda items? Not wrong.
Were there not some other public comments?
The public comments that were not read, Mr. Thacker, were comments where they were requesting to speak to a particular item on the agenda.
Which do we
Normally, we only hear public comment altogether, but I don't care.
I think Dr. Pace explained that, and we decided that we would wait.
Okay, so basically,
Yeah, that's fine. I missed that.
right. So Dr. Pace would alert when I call the item for a vote for nomination or I think Dr. Pace at that point will go ahead and alert us that there is a public comment on the item. Okay, so I don't see Mr. Booth, is still up?
The 2 blue sheeted items, they will be under 15.
I think it's 12.07 and 13.01.
Oh, they're already there. Okay, 12.07 and okay. And what 1301. Okay, thank you. And then I did want to, Mr. Chairman, just let everybody know that I did ask our assistant, Ms. Culver, to add the EPG discussion to the end. I think you can see it there on the agenda and board member comments and committee reports. I just wanted to have a little bit of discussion on that.
Absolutely. I'll just note that that's your item and I'll call you on that to initiate discussion. All right. So it's all pretty clear to me. We're going to take I'm going to call for a motion to approve the consent agenda where 9.61 and 10.4 will be.
I'll make a motion to approve the agenda and the consent agenda with the changes to superintendent
Very well.
applications.
Second.
So there's a motion to approve by Mr. Tucker and a second by Mr. Booth. Anything further from the board? Hearing none, we'll take a vote. All those in favor, please state aye.
Aye.
Aye, I couldn't get my mute off.
All right, I believe that then there's 5 votes to approve. The vote passes 5-0. That takes us to the next item. By the way, board, if I ever call a 5 vote, and because I miscounted, please let me know. So this takes us to regular agenda item 0.05.
Mr. Chairman, I'll make a motion to approve 10.05, understanding that 10.04 has been removed.
I'll second.
Very well. So motion to approve point 10.05, excluding 10.04 by Mr. Booth, second by Mr. Thacker. Any discussion on this item? I only see the superintendent's hand. I just want to verify. Dr. Pace?
You're still muted. She's still muted.
I do have a public comment to read into the item related to item 10.03, approval of the application for Pinecrest Academy Osceola campus. To the School District of Osceola County School Board, Pinecrest Academy Incorporated thanks you for your time and consideration of our charter school application for Pinecrest Academy Osceola. Please be advised that the following individuals will be available to answer questions regarding our application, should there be any. Judith C. Marty, Pinecrest Academy Governing Board Chair. Liliana Salazar, National Director for Special Education and Student Support. Willie Tagle, National Director of Security. Richard Moreno, Budget Consultant. Fernando Bararso and Adriana Lima, ESP Representative, and Elaine Clemente, HP School Mentor Principal.
Thank you, Dr. Pace. And I will give an opportunity for any board member to make any comments before we take on the vote.
I have none.
Castillo has a comment.
Castillo's hand, please proceed.
Thank you. Thank you so much, Mr. Chairman. And my comment is specifically about item 10.03 Pinecrest Academy. I understand that the charter is just being composed and that we have over a year for the school to open, but I did read their plan and I have a lot of concerns, and I'm so glad that they're actually online to listen to these comments. And I just wanted to go on the record. I have extensive concerns about specifically their lack of information with regards to how they're going to meet the needs of our students with disabilities. I also have extensive concerns regarding their safety plan, and I have extensive concerns regarding their professional development for their teachers. I understand that this is their first step and that they have the guidance of the school district in order to resolve some of these issues, but I do want to go on the record that I will not be voting for this school to go forward if I do not see that these issues have been resolved.
Thank you, Ms. Castillo. I understand that there may be folks on the attendees that may be able to not respond, but maybe shed some light into some of your concerns, Castillo. Sure. Okay. Well, then I will go ahead and ask our host to see if he can determine which of our attendees would like to address your concerns, and I would limit. And
if I can just make it clear, I understand that their application is just getting started, so I know that they have time to resolve these issues, and I'm fully aware of that. I've already had a conversation, so my comment wasn't to chastise them about today. I just want them to be aware that these are very specific concerns that I have and that I expect to see them resolved.
Absolutely. Absolutely. All right. Well, then in that case, I think that your caution is on the record, and because I refer to your judgment that you understand exactly and you have done your diligence of this, Ms. Castillo, I will definitely share your concerns. And maybe not at this meeting, but we'll have plenty opportunity and the school district to oversee the operation of this charter. And I trust that if the school district is asking for an approval of this application, that our choice department will be paying particular attention in what's going on at this particular charter. I will go ahead, and I believe it was Mr. Booth. Did you have a comment? Did you want to share?
No, call the question. I'm ready to vote.
Very well. At this point, I will go ahead and call for a vote. All those in favor, please state aye.
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 Nay, please state nay. Ms. Castillo, did you vote no?
No, once again, at this point, we're just voting for the plan to move forward. So they do have, and I just want to confirm that with Dr. Pace, they do have some time to resolve this issue. I just wanted to go on the record stating that I do have those concerns, and luckily, I know that Dr. Pace and her team will do their due diligence to make sure those issues are resolved.
Okay, and with those statements on the record, I believe we do have a 5-0 vote to approve, correct?
Yes.
Very well. So that takes care of item 10, regular on teaching, leading, and learning. Brings us to number 11, a regular agenda of business and finance. And I believe at this point, I am going to call for a recess. And
No. You need to vote on 11.01 first as the school board.
Very well. So
Motion to approve.
I have a motion to approve by Mr. Booth.
Second.
And a second by Mr. Thacker to approve only 11.01. Is there any comments or questions on this item before I call for a vote? Seeing no hands, Terry, you still have your hand up. I just want to make sure. Okay, very well. Seeing no hands, I will then call for a vote. All those in favor, please say aye.
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 I registered as 5, which takes us now to items 11.0203. And for those items, go ahead and adjourn for a regular meeting and convene. I guess
You are recessing the regular meeting and convening the leasing corporation meeting.
okay. Okay, so board, anything on item 11.02?
Are we voting as the leasing corporation for 02, 03, and 04?
Yes, sir.
Okay, can I make a motion to approve all three of those? 02, or do we need to do them individually?
Do the way they're set up, please do them individually so it gets properly
Motion
recorded.
to approve 1102.
Second.
Motion to approve 1102 by Mr. Booth, second by Mr. Thacker. Any further discussion? See no hands. Therefore, we'll take a vote. All those in favor, please state aye.
Aye.
I registered 5. Therefore, the vote passes 5-0. 11.02. Do I have a motion?
Motion to approve.
Second.
There's a motion to approve by Mr. Thacker with a second by Ms. Castillo. 11.03. Any questions or comments before we take a vote? I see no hands. Therefore, I'll call for the vote. All those in favor of 11. Aye.
Aye.
That registered also to me as 5 votes. Therefore, the vote passes 5-0. 11.04. We have a motion. Approve. 11.04.
Motion to approve 1104.
Your motion approved by Ms. Castillo.
Second.
Second.
Second by Mr. Booth to approve 11.04. I'll pause to see if there's any questions or comments before taking a vote. I don't see any hands. Therefore, we'll take the vote. All those in favor, please say aye.
Aye.
Aye. believe that's registered as 5 aye votes. Therefore, the vote passes 5-0. And that brings us to.
You would now adjourn the leasing meeting and reconvene the regular school board meeting.
Thank you, Mr. Kuppenbacher. So now reconvening our regular board meeting. And that does bring us to item 12, regular facilities. I believe that 12.08 would also include the blue sheeted item. So,
I'd like to pull out 12.07.
7, the blue sheeted item.
very well. Are we going to pull that out for discussion, or do you?
Yeah, for discussion.
All right. So can we get a motion to approve 12.08 without 12.07?
Individually. Mr. Chair, I believe we have to do the items individually if we're not going to do item 12.08. I'm sorry, 12.07.
So let's not take any vote, and let's go ahead and call for discussion item 12.07 to see if
that idea.
Indeed we are going to be pulling it. And
Well, my vote will be different on 12.07 than it will be on the others, so I can tell you now. I hate to have to do this, but
I
do the others individually.
I appreciate that, Mr. Thacker. I think that I want to hear what you have to say, because I may actually agree with you. The floor is yours.
Pretty much the issues I have on 12.07 I stated in the workshop, and I know we have to get moving on this. I realize we need to just start comfortable, and I will probably needs to be done, but I can't support it at this point.
Okay. Does anybody else have any comment or want to further discuss item 12.07? I don't see anybody's hand.
Mr. Chairman, I guess what I could do just to make this easier is get the process started. I'll make a motion to approve item 12.01.
And I'll second that.
Very well. So we'll have a motion to approve point 12.01. Is there any questions or discussion on this item? I'll wait for hands. Mr. Thacker, you still have your hand, but I don't think that's for this.
I'm putting it down. I'm sorry.
Very well. So I see no hands. Therefore, I'll call for a vote. All those in favor of 12.01, please state aye.
Aye.
And I believe that registered as 5. Therefore, the vote passes 5-0. Do I have a motion on the next item?
Mr. Chair, I would like to make a motion to approve item 12.02.
Second.
There is a motion to approve 12.02 by Ms. Castillo and a second by Mr. Thacker. I'm waiting for hands and for comments or questions. I see none. Therefore, I'll ask for a vote. All those in favor, please state aye.
Aye.
And that
motion to approve 12.02.
passed with a vote of 5-0. And on item 12.03, I hear a motion to approve by Mr. Thacker.
Motion to approve.
And a second by Mr. Booth.
Sure.
Waiting for hands to see if there's any questions or comments, and I see none. Therefore, I'll call for a vote on 12.03 to approve. All those in favor, please state aye.
Aye.
And I registered that 5 aye votes. Therefore, the 12.03 passes 5-0. On 12.04, do I hear a motion?
So moved.
Second.
There is a motion to approve 12.04 by Mr. Booth, seconded by Mr. Thacker. Waiting for hands for questions or comments, and I see none. Therefore, I call for the vote. All those in favor of item 12.04, please state aye.
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 I registered 5 aye votes. Therefore, 12.04.
Make a motion to approve 12.05.
And there's a motion by Mr. Thacker on 12.05,
Done.
second by Ms. Castillo. Waiting for hands for questions and discussion, and I don't see any. Therefore, I'll ask for a vote on 12.05. All those in favor, please state aye.
Aye.
Register 5 aye votes. Therefore, 12.05 is approved at 5-0. You know, I can barely hear Tim, but I think that I do hear aye from him. Calling now on the item 12.06. Do I hear a motion?
I'll make a motion to approve item .06.
Second.
All right, so I hear approved by Ms. Castillo, 12.06, second by Mr. Booth. And waiting for questions or comments, but I don't see any hands. Therefore, I'll call for a vote. All those in favor of 12.06, please state aye.
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 Good. I did hear 5, therefore vote passes 5-0, brings us to 12.07. Do I have a motion to approve?
Motion to approve 12.07.
Second.
I have a motion to approve 12.07 by Mr. Weissier, second by Ms. Castillo. To ask, I'm going to wait for hands to see any further comments or discussion.
Me, I'm raising my hand. There we go.
Okay, now I see it. Mr. Booth, the floor is yours.
Yeah, Chairman Soto, thank you very much. I appreciate all the work that Mr. Thacker has done on this and researching this, and I've done my own research as well. And I certainly want to get this project done. To be honest, I don't believe that the questions were answered and the issues that Mr. Thacker brought forward have been resolved. So I will be voting no on this item tonight.
Very well. And I'm just waiting on hands. See any other hands? So therefore, I'm going to go ahead and call for the vote. All those in favor, please state aye.
Aye.
I believe I've registered 2 ayes. Mr. Weissier and Ms. Castillo, correct me if I'm wrong.
Correct.
All those against, please vote no. No.
No.
Here 3 no votes. Just to be clear, because we're doing this through the WebEx. That would be Mr. Booth and Mr. Soto voting nay. The motion therefore does not pass, and 12.07 is not approved. That takes us next to items 13, school operation. That is a repeated item. Do I have a motion to approve 13.01?
Motion to approve item 13.01.
I'll second that motion, that item to approve 13.01. And then there is a second by Mr. Soto to approve. I'll wait for hands before, and I do see 1 hand. Therefore, I will call on District 5, Mr. Booth. Yours.
No, I appreciate. I have reached out to Dr. Pace on this, and I just want her to know I appreciate the discussion that we had on it. I am going to support this. I do. I'll just let me be very upfront about that. I want our kids to be fed out there. I'm going to share my one concern with the board. I understand this is a restaurant that'll be working in Osceola County, and I'm sure there'll be some Osceola County residents working in it. But I'm going to tell you, and I have friends in the business, there's a ton of restaurants that are owned by Osceola County residents. And I don't know how all this went forward and all this went through. And I've had some discussion with Dr. Pace on that, and I don't need to get any deeper than that because this organization and these folks are really wonderful people. Don't get me wrong. And the money, they're not making any money on this deal. They're probably losing money on this deal. I get that. Just want to make sure that our folks in Osceola and our Osceola-owned businesses, Osceola-owned businesses are getting opportunities for some of these things that are going forward. And I know the way that all this came forward, maybe didn't warrant that. So I get that part. And again, this is a great company with great people, and they do have businesses right here in Osceola. I get that. I just need to make that point. And that's it, Mr. Chairman. So thank you.
And I appreciate your insightful comments, Mr. Booth. I share with them, and I do appreciate that we're seeing that involvement from private entities and private companies to help us through this through everything that's going on in this pandemic. And of course, I do know with Dr. Pace's leadership and this board, I believe it's always looking for opportunities to just get everyone that we could, every entity and business partner in the community involved with what we do. And so I'm gonna just give it a pause real quick to see any other hands. And because I see none, I will go ahead and call for a vote on item 13.01. All those in favor, please say aye.
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 I believe I registered 5 votes, therefore, item 13.01 is approved 5-0. And this now brings us to item 14.01, which is the attorneys. Mr. Cooper, I'll let you go ahead and introduce us to this meeting. And then I'll call to see if there's any motion to approve.
Members of the board, you can hear me. Members of the board, if you recall, several meetings ago, there was a presentation by Attorney Scott Glass on behalf of his client regarding their request that the board approve an alternative calculation on the impact fee based upon the following factors, which would distinguish them from everything out there, and that is the complex would be limited to 2 persons, maximum occupancy. Each unit would be less than 350 square feet and could not be combined with other units. There would be basically 0 bedroom and a 1-year lease. We received an initial recommendation from our Tyndall Oliver consultants to apply the townhome impact fee rate. The proposal for the alternative agreement that's in front of you came subsequent to that recommendation after discussions with staff and the applicants regarding why they think they would be eligible and an agreement they thought would properly protect the school district. We have brought you both alternatives for you to decide which one the board wants to go with. And that is where we are as of this time.
So I do have some hands up, Mr. Kuppenbacher, although you may still be called upon to shed some further information. I will go ahead and start with this. Mr. Thacker, if you will permit me, I'm going to start with Dr. Pace, as it is the district. And
Sure, that's fine.
very well. Dr. Pace, you have the floor.
Chairman Soto, we have 2 comments related to this particular agenda item. They are both lengthy, so I will start my timer. If it goes beyond 3 minutes, we'll stop and just make sure that it is a matter of public record.
Very well.
The first is, dear Chairman and members of the board, first and foremost, on behalf of myself, my client, the Styx companies and their subsidiary, the Teal LLC, I hope this letter finds each of you healthy and safe. Second, I would like to express our collective gratitude to Dr. Pace, Ms. Blake, Mr. Kreppenbacher, and all those who have worked with us to negotiate the agreement for alternative educational system impact fee, which is on your agenda for consideration as item 13.01 at your April 27th board meeting. As you know, my client first submitted its application for such an agreement in June 2019. For your convenience and in order to incorporate the same into the official record, the following is a brief chronology of salient events with respect to the application. Chronology of application. In June 2019, Styx companies submitted an application for an alternative educational system impact fee, the application for 300 0-bedroom units ranging in size from 187 square feet to a maximum of 350 square feet. Styx intended to create through conversion of 2 existing motel properties. In support of the application, Styx submitted an educational impact fee alternative calculation for 0-bedroom housing units, the alternative fee study, which was made a part of and is on file with the application. On July 19, 2019, the school district's impact fee consultant, Tyndall Oliver, sent a letter to Ms. Sarah Graber, CGFO, the district's chief business and finance officer, advising that Tyndall had reviewed and verified the data used in the alternative fee study and recommended accepting its findings, to wit that 0-bedroom units generate on average 0.019 students per unit. Among the reasons stated for its recommendation, Tyndall noted that an alternative fee should be accepted only when the student generation rate is tied to physical characteristics of the building, and that the lack of bedrooms and size of units up to 550 square feet would provide the necessary physical characteristics. On July 30th, 2019, the application was pulled from the board's July 30th agenda without input from or explanation to Stix. In October 2019, Stix retained Schutz and Bowen LLP and the undersigned to represent Stix in their effort to negotiate a fair and reasonable agreement for alternative educational facility impact fee as provided in Section 24-41 of the Osceola County Code. On November 7th, 2019, the undersigned sent a letter to Ms. Rhonda Blake inquiring as to the status of the application and noting that given the recent validation of the educational impact fee alternative calculation for 0-bedroom housing units study by the professionals at Tyndall Oliver, a firm the district itself has acknowledged and relied upon as experts in this field, our client is hoping to receive a response consistent with 2441E of the code. Such a favorable outcome would certainly appear to be justified by the inherently limiting physical characteristics of the proposed apartments, which range in size from approximately 187 square feet to approximately 350 square feet. That is the end of 3 minutes, Chairman Soto. So with your permission and also with School Board Counsel, we would read the rest, or we would hold the rest of the letter into the permanent record.
Very well. Is there any other comment?
Yes, sir, there is an additional comment.
Okay, please proceed.
Let me then start the timer. My name is Ryan Heiler, and I am principal of Stix Companies and the Teal developer of the 300 0-bedroom units in question. As you know, we applied for an alternative impact fee almost a year ago. We have been working with staff to come up with a reasonable agreement that is fair to both parties. As you consider it this evening, I'd ask you to keep in mind the following points. We originally submitted our application to the school board in June of 2019. We were pulled from the agenda in July and did not receive any further communication from staff until we engaged an attorney in October. By statute, the burden is on you to prove that the impact fee being imposed is proportionate and reasonably related to the impacts we'll generate. Looking at the record in this case, not only does evidence support the proposed agreement, the truth is that pretty much all of the competent evidence favors the agreement. For example, you have our application and our prior testimony confirming that our units will range in size from 187 square feet to a maximum 350 square feet, and that all units will be subject to a legally enforceable 2-person per unit occupancy restriction. While some units may have 1 adult and 1 child, at the contemplated rental rates, that is very, very unlikely. In support of this conclusion, you have the detailed study we submitted. It looked at 9 Central Florida apartment complexes with units ranging in size from 288 square feet to 550 square feet, and each of which, like ours, has a legally enforceable 2-person per unit occupancy restriction. Per Section 24-41F of the Osceola County Code, the proposed educational system impact fee and support documentation shall be submitted to the superintendent, who shall review the calculation and provide a preliminary written determination to the applicant within 60 calendar days of submittal as to whether such calculation complies with the requirements of this section. This was not done. In fact, even your own consultant put in writing that they agreed with the conclusions of our submitted study. That's some pretty substantial competent evidence. On the other side of the scale, all you have is your staff's limited count of students residing in 4 motel buildings whose owner apparently claims were converted into 0-bedroom apartments. Based on that very limited and unverified information, your consultant gave you a 6-sentence letter saying that this specific 0-bedroom unit project is pretty much the same as townhomes. However, our attorney provided you documentation in February refuting such conclusion and any claim that backlot apartments are comparable to the Teal. According to information readily available on the internet, Backlot's own advertising shows multiple double beds in a single unit and also notes that 4 occupants per unit are allowed. Our agreement as drafted will limit occupancy to 2 individuals per studio apartment. Comparing Backlot to the Teal is clearly comparing apples to oranges. All we are asking is for you to treat us fairly. Per the agreement, if our numbers are wrong, we will all know soon enough and you will get the difference out of the escrowed funds. Finally, if all this does not convince you and you reject the alternative impact fee study we submitted, then I would remind you that pursuant to Section 24-41, and that concludes our 3 minutes, sir.
Finish that last part, if you would, please, Dr.
Such
Pace.
rejection shall be in writing and set forth the reasons therefore and shall be provided to the applicant by certified mail. And that concludes the comment.
Thank you. All right. So I do see, thank you, Dr. Pace, and I believe that was the purpose of your hand.
Yes, sir.
Therefore, I will go ahead and call on Mr. Clarence Thacker. He has his hands up for comment.
I just want to say traditionally what we have done is we've done a study every 3 years on our impact fees. I do understand the statute. I do understand that we're obligated to charge based on the impact. I also understand that we cannot have
every single developer come in throughout that 3-year period and change and want special exceptions. If we do, this thing will get so unruly, we will never be able to manage it, and we'll never even be able to understand it. Right now, we have the criteria that were set out on the study. I think, somebody correct me if I'm wrong, approximately 2.5 years ago or so. I think we live within that range. We've done that in the past. When the last one came around 2.5 years ago, there had been a lot of comments and a lot of questions about some of the vacation rental homes not generating enough rates. We looked at that. We adjusted at that point. The developers understood what we did. They were participated in that process. It was one where maybe everybody wasn't happy, but things have not slowed down in that area. And we have an agreement, I think, which has worked. So I am hoping that, and my understanding is we will be doing a study at the end of the year, before the end of the year. At that point, welcome to this be adjusted. I will tell you, and I wish sometimes this were not the case, the demographics and the rental rates and the home values in Osceola County are different than what is in Orange County. We have a different clientele in many cases, not all, but some. To use them as comparisons, I'm not sure I agree with that. I understand you can say the size is the size and everything else, but a 300 square foot condo in New York City would be worth a lot more money and have more kids in it than one in Osceola County. So I'm not sure I believe that that's not an apples to bananas comparison, even though we're close. We have very different demographics and very different economies. So based on that, I'm willing to look at the two proposals that we have here, but I'm not really willing to bend a whole lot further. I have listened to what the consultant said, Tindall Oliver, on, and correct me, Frank, if I understand this incorrectly, that they are saying that they could view them in a similar vein as a townhome, which already has a calculation and a rate in our impact fee structure. Is that correct?
Yes, Mr. Chairman, let me explain that to you. What Tindall Oliver came back when we got into this number 2. Their position is that the townhome rate would apply to new construction. They articulate to us that they considered the proposal by Teal to be reasonable and one that could not be replicated unless you met these conditions of a conversion with the limitations that have been specified. That was a further modification to their original opinion.
Thank you, Mr.
Mr. Chairman, can I make one more comment?
Yes, sir.
I do kind of want to point out also that when we did the last impact fee study a couple years ago, while we did reduce the impact fees on the vacation rentals, we had another class of the apartments, single family apartments, that we did actually increase. And in fairness to this process, we knew that was out of whack, but we waited for the 3-year process to come up and reevaluate that at that time too. So it goes in both directions. There are things that are probably a little more in our favor. There's some things that are a little less in our favor, but I think doing it a whole lot more than every 3 years and certainly one project at a time is not a reasonable course for us.
Thank you, Mr. Thacker. We'll call now on Ms. Terry Castillo. She has her hand. The floor is yours, ma'am.
I apologize. Thank you so much, Mr. Chairman. I just have a couple of questions for Frank. Again, for me, the question is, what happens if we accept this as precedence? When will our next impact fee study be done?
Well, we're in the process of requesting bids for consultants. That process is not done yet. And once we retain the consultant, I think we'd begin gathering data in the fall and be done by the spring at the latest with a study.
By what?
I think we'll be done by the early spring at the
Early
latest with
spring
a
of
study.
2021?
Yes, ma'am.
Okay. Okay, thank you.
Steve, would that conclude your questions or comments? All right. So if I understand this correctly, I can entertain a motion to approve number one, which is to deny. It's kind of like it's kind of a strange way of doing it. We could either approve the denial and uphold the district's position, or we could make a motion to approve number two, which is to overrule the district and accept the alternative study with the agreement. Am I stating that correctly, Mr. Kupenbacher?
Yes, I would only add so you know, we are likely going to see litigation on this, and advise you where our consultants are on the agreement. So that's one of the reasons we sat and literally tried to negotiate an agreement that would protect the district, was to avoid that potential.
Very well.
Mr. Chairman?
I've got a question.
All right, so let me go ahead with Mr. Tim, with Mr. Weissier, but then I also have Ricky Booth, Mr. Thacker with their hands up. So let me just take it in that order, if I may.
Thank you, sir. Mr. Kruppenbacher, I've read through the impact fee calculation document as it's been prepared. My understanding, if I'm tracking with everything correctly, is that at this point, if approved, they would pay a $552 per unit fee, respective 100 units on one, 200 units on the other. Am I correct? And then in addition to that, they would place in escrow the difference of any amount that would have otherwise been collected by the school board at this time. Within that 3-year period, there would be an ongoing biannual monitoring and recalculation of student generation to see if what we're doing is actually bearing out. And if for some reason we had a higher student generation rate than what is anticipated in this proposal, there's an automatic trigger that allows for the school board to then collect the difference of what we ultimately would have been owed because the units are not performing in the way that they are being presented to perform. Is my assessment correct around everything?
That's correct, but I believe if it says 3, that we had, if we thought it, we wanted that to be 5 years, because our consultants said it would be, in their opinion, a year or 2 before the apartment complex was truly ramped up.
Okay. And it's your understanding, based on your review of all of this and your work on putting together this document, that it's in the, and you can change my words however you see fit, but it's in the best interest of the school board to approve this amended study and to move forward with the methodology that's laid out here, including the protections and provisions that you've built in for the school board to recapture if indeed things don't perform as noted.
I would respond that as your counsel, we have the burden of proving what the rate is reasonable. Under the county ordinance, it permits an applicant to propose a different rate. We have not had, we had that original rate board rejected based upon data not locally. The reality is the district employs a consultant who is advising us that this is reasonable. for the protection of the district. I asked the following questions. Could this be used? And they said, no, it would have to fit this model. And literally by the time we're done with the study, the reality is, particularly given what we've just seen happen, there's little ability to really replicate this exactly. And if they did, we'd have these controls in place. So the board understands every October and February after the FTE count, this complex, if you adopt number 2, would be audited. And if it was producing more, then payment is made out of the escrow, et cetera. So when I say that we have the burden going to court, so you're aware, the burden is I've got a consultant saying they think this is reasonable.
Sure. Thank you. So additionally, with these audits and reading through the document, the landlord, the developer, would be responsible for paying costs associated with those ongoing audits, if I understood that correctly as well.
They will require, the consultant we use right now would be Tyndall. They will pay their fee. I think it was capped at $5,000 or something like that per audit. And they will do the audit for the board.
Right. And then to go back to your point about the 3-year, 5-year, it's 3 years from the first certificate of occupancy. So right. If they have a ramp up period, yes, then that would maybe be a 2-year time period to your theory about what the redevelopment would look like. Addressing Mr. Thacker's concern, which I don't disagree with, his concern about we've set a schedule of impact fee studies. We've been very consistent in how we've dealt with that, and we have shied away from breaking that pattern. However, as I sit here now and I think about the fact that within our own ordinance, there is language that says that an alternative study could be proposed. That I think for me is an issue. Our language says it's allowed. Our consultant says this is justifiable. And then we're sitting now potentially with the circumstances saying that we either, 1, don't like our own language, our own ordinance, or 2, that we disagree with our consultant, which was certainly welcome to do. To play that forward, are we able to, at the next impact fee study, to work on having that language removed that says an alternative study could be proposed to mitigate this, or is that requirement in all impact fee ordinance language?
I've seen it in every impact fee ordinance I've ever looked at because of the fact that there's always some new thing that nobody thought of. I would like to go back to what you just said. Dr. Pace and I, to start with, were just lined up, trenched with where Mr. Thacker and the board had been. What threw the curveball to us was when the consultant came back and said, no, that's a reasonable approach, because Dr. Pace was holding firm. I was holding firm. We're waiting till the next study, but now got our consultant telling us, no, this is reasonable.
Sure. And I think I'll end on this board and turn the floor back over, but I think Mr. Kruppenbacher and board, that is one of my biggest concerns here, is that the language allows for an alternative study to be done in theory, and not even in theory, in practice. I have supported exactly what you just stated, Mr. Kruppenbacher, is that no, we have a pattern, we stick to our pattern, we're not going to break from it, which I believe and understand, Mr. Thacker, is your position as well. But now I find myself in the situation to where, due to language, due to process, and due to analysis, we find ourselves having to make a decision. Do we break from that, understanding all of those other pieces and parts? I'm open to hearing other debate and discussion from the board, and I could be swayed, I think, on this, but the board, to be clear, and you probably already could tell where I'm at, I'm leaning in favor of adopting the ordinance change and allowing for the alternative study to be utilized for us to move past this. So I'll yield the floor back.
So I have Mr. Booth and Mr. Thacker. Which one of you would like to?
Let me go, if you don't mind, Mr. Soto.
Okay, Mr. Booth, the floor is yours.
I'd like to say, Mr. Thacker, I don't just agree with him. He's right. when he states that he's wrong. I mean, that's what I was going to say. We're not comparing apples and bananas. It's not even fruit when they're comparing what they're trying to compare. I get that. However, Mr. Weishauer just walked through all the points the questions that I was going to ask, or at least make the public aware of, and actually agree with his stance on this. And with that being said, I'll make a motion to approve option 2. Let's get this done and out of the way. I think the ordinance does have the language in it that does provide for this. I don't like that we're going through this. I don't like the way that this is being done. I certainly don't like some of the language that was brought forward by the applicants tonight. That's neither here nor there. I do think the ordinance falls on that side. I don't want to say their side, because it is part of the ordinance for a reason. And so with that, I will support it. I will make the motion for option 2.
Thank you. I'll second the motion, Chairman.
We have the motion and by Mr. Booth and a second, but we still have discussion. And so I'm going to call on Mr. Thacker to go ahead and you have the floor. Make your comments or questions.
One, I got a question, then I have a comment. The thing in the ordinance that says people can bring the alternative studies, Dr. Pace, when you said that, did I hear you say, is that in our ordinance or is that in the county's ordinance?
County.
That is in the county ordinance, sir. Our impact fee analysis is a part of the county ordinance. If I'm not mistaken, Frank, correct me if I'm wrong. Keep in mind that once the board approves a recommendation for impact fees, that goes back to the county to be incorporated into the overall impact fee county ordinance.
I understand that, but it's not something that we had put into our ordinance. It's something that came from a different group.
Other than our study, Mr. Thacker, the county ordinance is solely owned by and controlled by the county, not the school board.
Right. And that's a subtle difference to me, but I still think it's a difference. My next question is, we're saying we have a consultant that agrees with them, but at one point, and maybe something has changed and I missed it, which is fine. I thought the consultant says that these should be charged then at the townhome rate, which I believe is significantly higher than $500 and some odd. Is that old news or new news?
What happened was in July, the consultant provided us guidance that in new construction would support the lower rate. The second letter in December supported conversions at the townhome rate. And then this idea was brought forward, flushed out, and they took the position this is reasonable. And I will just put on the record, in a interview with me and Ms. Blake, it was readily apparent that our consultants were not the people I would want to stand in court with on this issue. I'm just telling you straight up without saying anything else.
Okay. One more comment, Mr. Soto, if that's okay, and I'm done.
No, we still have a lot left. Go on,
Okay.
Thacker.
I'm sorry, can I go on?
Yes, sir.
Okay. I lost my train of thought now. The difference in the townhome rate and this rate, I guess where I was going is, let's not forget that we kind of collect impact fees behind when we need student stations already. In other words, housing development comes to town, we need to build a school so that they have places to sit the day they get there, and we don't get the money basically until about time they get there. So it worries me a great deal to set this precedent where somebody can come in and say, okay, we're just going to give you $500 and we'll escrow the other $10,000 until 5 years from now or whenever you can prove that we were wrong, and then we'll give you the money. We've already built a school 5 years before that. So this puts a burden on the school district, I believe, that's also undue without knowing for sure what is going to happen. And I understand that they think they know for sure that it's not going to be any students or very minimal. I know that it's an undue burden on the school district when it goes in the other directions, and it's higher than we anticipate. So I certainly, it's a very tough issue. I understand Tim and Ricky's stance, but I think it opens up some precedent, which makes me extremely nervous where the next group comes in and says, I'll give you $20 and I'll hold the rest till you prove me different. And I know this is an extremely specific ask based on their square footage and 1-year lease and all that. It doesn't take very much to have the next unique ask by making it a 1-year and 1-month lease or whatever. So it's a very slippery slope to get so specific and have everybody with a different specific thinking they need and deserve something different. So that's all I have. Thank you.
Yep. And Mr. Soto, if you don't mind.
Actually, I do. I want to give Ms. Castillo
You do?
an opportunity. Yes, only until after Ms. Castillo had a chance to go. And then Mr. Booth, it'll probably be me before I call you.
That's fine.
All right. Ms. Castillo, you have the floor.
Thank you, Mr. Chairman. I do want to go on record saying that I do share Mr. Thacker's concerns, and I have a redundant question for Mr. Kroppenbacher, but I'm going to ask anyway because I need to be very clear. One of the arguments that you put forth for why this alternative calculation would not set a precedence is because, like Mr. Thacker said, the unique circumstances of this particular developer. Can you walk me through what these parameters are? What is it that makes it so unique that it cannot be replicated tomorrow?
It could be replicated if somebody came in with a 2-person maximum occupancy, less than 350 square feet, 0 bedroom, 1-year lease, and you couldn't expand. Now, if they came in at 400 square feet and the others, and I'm going to go back to the problem as your lawyer. The consultants effectively said, we can support the townhome right and we can support this agreement. So we have to, the burden is on us to articulate factual reasons for denial of or why the rate we're charging it. Consultant tells me on one hand that they can support a townhome rate, and they turn around and say, but we can support the agreement. I emphasize that because that's an underlying thing that concerns me greatly as the lawyer, because I don't have an expert driving standing on the rate. And we would have to articulate in court the basis for it. Now, if we said, and we have no data, other than if you took data from other counties, which we've rejected, which would mean somebody'd have to decide who's reasonable, who isn't. So we came up with an agreement that would basically put us in a position while we didn't have data, that we had a safeguard if they produced more kids. And in the short interim, which would be about the next 10 months, we get another study done and look at this issue. And the theory was with these kind of limitations, we wouldn't see this again. That's not to say, and I think Mr. Thacker's right, and it's something I've always been concerned about. Somebody would come in and say, I'm building a, 1,000 unit whatever, and I'm going to limit it to this and this, and we'd be facing the issue potentially. It's one of the things that I want to meet with the county on, that certainty is a critical thing for this school district, and having the ability to alter what is in place, whether it's reasonable or not, creates a level of uncertainty. So agreement 2 was designed and to get as much certainty as we could that if kids were generated, we would be paid the fee that should be paid.
Ms. Castillo, you still have the floor.
I have no further questions. Thank you.
Board, let me go ahead and chime in here, and then I'll call back on Mr. Booth and Mr. Thacker, I do see their hands. First of all, I've had time to review the letter that was written and also to ask the questions of the district, and find out what's been going on with this request. And I'm going to start by saying that approval of this agreement absolutely hurts our schools. It hurts our students. We're absolutely defunding public education. That is no question. And although it has not been brought up, I want to go ahead and make sure that everybody knows that I understand this as such and that is clear. I think that I want to go ahead and spend a little bit more time in the technical aspects of why this recommendation is, first of all, before us, and why, and some of the reasons that was already articulated by several board members in support and what I consider in opposition. Well, the first thing I want to say is that I completely disagree with Mr. Weishire's dichotomous description of this issue. Board, when we have something coming upon us, there are so many factors that we must consider. Many, many factors. And not only that, some factors require us to, I think, in a prudent manner, to defer to the judgment of those folks who we have entrusted with making these decisions and who have been trained and for many years been looking at these topics and developing a deep and thorough understanding. That does not mean that we approve everything that the district does or requires. It's just a way that we have pragmatically approached these things. And with Dr. Pace and her staff, I have to say that it has served us well. There may be some questions as to, and I mean, for some, not to me, that we are obligated as the petitioner here is almost trying to say, and I think that I hear our board attorney also stating that, although it's not really clear what would happen if there's litigation. However, I want to address certain points in order. First of all, the threat of litigation should not be an overriding reason as to why we approve requests. I think that it could be considered. I think it could be considered in light of the strength and, of course, the opinions of our learned counsel. But that is not a reason why we should take a vote on approving or disapproving anything. I think here, I disagree with Mr. Krupenbacher with his predictions, and I think that this is actually something that can be, really, really developed through a discovery process and litigation process that maybe such a topic deserves. Second thing is I want to address is the consistencies, the board's propensity to really want to have follow precedent and to be consistent. And I think that approving this violates both of those. I think it does set a precedent. I think it'll set a precedent even after we do the scheduled impact study. I think it sets up a scenario where we would be pretty much, having the school district and the school board always looking over his shoulder about when somebody's going to invoke this new recipe to again, challenge whatever fees, which, by the way, were already adopted and in full notice of anyone, who was going to develop any kind of properties here. There's no surprise here whatsoever. There's only a technique that can be explored in order to circumvent what policies we already have. And consistency is important here. I think it's very unfair that we go ahead and what it has been presented to me by some of the arguments by the other board members and the attorney that this is a one-off. And I don't understand why we even have to have that, considering that what we're really talking about here is school funding. I can go ahead, there's more, but you know what? I want to stop here. But if I have to, and you want me to elaborate more, I will. I would definitely vote against adopting this agreement. And I would urge the board members to also vote against this. And that will conclude. I will go ahead and call on Mr. Thacker, then Mr. Booth. Mr. Thacker, I'm sorry, Castillo, were you speaking?
Mr. Chairman, can I respond either now or when everybody else is done?
Yes, I see your hand, but let me take care of the board members first. Okay, Ms. Castillo, did you have something? Very well. Mr. Thacker, you have the floor.
Yeah, I just have a question of Mr. Krippenbacher. Frank, I've seen too many times in planning commission meetings and board meetings where somebody comes in and they get approval for a project and they have great pictures and it's going to be really nice and it's only going to have 1 or 2 adults and it's not going to have any kids in it. And they get the approval and then they have rights basically for numbers of units and sizes. And then they sell the thing. So I don't understand this is Stick's idea and they want to move forward to this. If they sell this to Stone's place tomorrow, are they going to be bound by these exact restrictions? In your opinion?
Mr. Thacker, I have said that if they were to do this agreement, it would have to be recorded on the land and it would have to have consent of any mortgage holder so that there is no way any sale could take place where we had an issue with the agreement.
Is that in the agreement that we'll be voting on tonight? That would be no.
Yes.
If the answer is no, I'd like to ask the 2 motion makers if they would allow.
I believe
It's in section 9, Frank.
Yeah, I'm going.
There,
It is there. We had it in there that it would be binding on all successes and assigns. The only way to do that is to record properly.
Okay. Okay. Thank you.
Mr. Thacker, maybe for your benefit, just to make sure that what Frank is referencing addresses your specific concern. I'm looking at the document. It says this agreement shall be binding upon and shall inure to the benefit and burden of the heirs, legal representatives, successors, and assigns of the parties, and shall run with the King's Heath property and to the West Earl of Bronson property, and shall be binding upon the successors and assigns of Teal and upon any person, firm, corporation, or entity who may become a successor in interest of the King's Heath property and the West Earl of Bronson property. Does that
Tim,
address your concern?
What page? Oh, never mind. I just found it. Page 10.
10 at the bottom. Yes, sir.
No, I think it does. Rather than hear everything you said, I was looking for it. So keep going and I'm going to read it.
I read it all. That's it.
Okay. No, I mean, let me read
I want to
this.
make sure it addressed your concern.
I'm going to read it now while I think Ricky had some comments or questions. So.
Okay. So I'll call Mr. Thacker. I will call him Mr. Booth at this time.
Yeah, and Chairman Soto, thank you very much. I just, I'd like to repeat, and I think it bears repeating, that I absolutely agree 100% with the concerns, the slippery slope issue that you both mentioned. I think it's apropos here. Absolutely 100%.
I
know. I do think that looking at the ordinance and looking at the situation we're in, looking at the escrow, all the things that Mr. Weisshire laid out, it's not voting on something because I like it, because I certainly don't. But I do believe personally that this is the best way forward here. I know we're going into the next step of having our impact fee study done again. Certainly, I'm in favor for that, and I'm in favor for somebody else doing it. I'll go on the record and saying that. That was going to be the second part of my comment, is that I am in favor of somebody else doing that this time. I'm in favor of looking at some of this language on the county side. As Mr. Kruppenbacher, I've had concerns about that in the past, and as Mr. Kruppenbacher has stated. So let's do that. But I do believe that this negotiated recommendation that the staff is bringing forward does at least get us somewhere here and moving on this issue, which I think is a very unique and specific issue. But I do share your concerns. I want you both to know that.
Mr. Chairman.
Okay. I'm going to make a comment here. And then who's hand up? All right, then you can follow mine. So here's another issue that happens, and this has to do with the whole agreement and the escrow. I don't, and here is where I'm not going to go ahead and make any legal opinion or anything like that. As a board member and as a policymaker and as someone who, again, I'm in this position because I support public education. I support what this school district can offer and do for its community, for our parents and our students. And under that thinking is, I definitely would not approve or like for the school district to enter into some kind of agreement where there is a potential to discriminate. I can see that here the whole almost the leasing policy is designed in order to circumvent what are impact fees, what is public funding. It's definitely possible that and especially given the demographics and the income levels, that these living that these apartments or houses or housing, whatever it is, it's appropriate for a single person, with a child or two, and and this may be actually something that I just can't imagine that because of this policy and because of this decision, that those folks are going to be shut out from being able to find a place to live. And then adopting this is actually makes us complicit. So I wanted to hold back that. I wanted to hold that back because that's more of a moral issue that I have with it. I think that the possibility is there. I certainly do see the design. Absolutely problematic for me. There's just no, there's just nothing else I can really say about that. We have, I don't see your hand, Mr. Weissire.
I don't know how to raise it on this thing.
Okay, go ahead, and then I'm just going to go back to Clarence, Mr. Thacker, after this.
Chairman. So first I'll start with, it sounds like everything that Mr. Booth has articulated is exactly where I am, which includes affirming most of your positions, Chairman, as well as what I believe to be all of Mr. Thacker's positions in this instance. I say most regarding yours because had the lease provision not been included or the occupancy provision not been included, then my assessment would be different because I think it would trigger the higher impact fee at that point in time. And only because of that being in place do I think it creates the scenario whereby we need to look at this. That's the only distinction that I would make with any comments that you've made. Otherwise, the comments that you've made this evening and the comments Mr. Thacker made, to be candid with you, I agree with. And I'm not excited necessarily about where we find ourselves at this time in this situation, because in truth, I would like to stay on our regular cycle of 3-year impact fee studies and not breaking from that. I share as well. I know Thacker said it, you may have as well, Mr. Soto. I share as well, and I know Ms. Castillo said it, the concern about a slippery, what might we create in doing this. I do lean, though, to our legal counsel on this some, and I have looked for affirmation from him that the document's been prepared in a way to protect the district in the best way possible. So I guess my point would solely be that I don't want the board to think that this is a right or wrong, meaning between one another, because I actually don't see it that way. I think we're all looking at it from all different angles, having very similar viewpoints on different things and landing at a different place in the final decision. And I respect that. And I respect that we may not agree where we land on this. Board, again, I'll go back to, I don't see how tonight I vote against this, although as I shared earlier, this has been good discussion, and every time one of you speak, I learn something new or I reassess my thought process, and I'm open to that, but I'm still inclined to move forward with the recommendation.
Before I call on Mr. Thacker, because of the importance of, because this has direct impact on our budget and our school funding, I would need to go ahead and invite Dr. Pace to go ahead and make some comments and chime in. We definitely need input.
Thank you, Chairman Soto and members of the board. As Mr. Weishire said, I think we all are in agreement on the situation and very much how we feel about it, in terms of, I believe that our commitment as a board and as a school district to engage in a comprehensive study every 3 years, to look at market conditions as they have developed, and to use our local longitudinal data to make firm, defensible decisions about impact fees is critically important. I also share concerns about the one-off with this particular situation and the fact that it could open, a ton of doors. I go back to, as some of you have mentioned, the work that we did 3 years ago when, as I first became a superintendent, we received tremendous pressure and concerns from the short-term rental group. However, we engaged them through the process of our study. And while in the end, not anybody wants to raise impact fees, everybody understood that we had used data that was local, that was longitudinal, that was reliable and defensible in reaching the conclusions that we did. And the board made very hard decisions to raise those impact fees at the time. I think in January, when we're looking at another study, after the election this fall, we'll have different numbers as the situation changes, particularly even now with COVID-19. Certainly, there are concerns about our capital budget, which is so heavily reliant on sales tax and what the pandemic and the shutdowns will mean for that. But I do support where we are in our work with Mr. Glass and with Teal and that organization. They have worked very, very diligently in partnership with the district to try to strike a balance between their interests, their data, the way they believe their product is going to perform in the market, our concerns about what's happened in the past with products of a similar nature and the fact that Osceola County's demographics are different than others in the Central Florida region, and provided that protection through the escrow piece that Mr. Kruppenbacher has mentioned. It also does provide the protection, as Mr. Thacker questioned, in terms of successors. Should Teal decide to sell this development to somebody else, are they bound by similar conditions? And it does give us the teeth that we need to, over the course of the next 3 years, every time we have an FTE study, to engage again in an analysis of how this product is performing, and then go back to them and say that money in escrow is the district's money because you are producing students, and we do need that to build seats and serve the needs of our students in our community. So I would also support at this point in time the acceptance of option 2. I don't like it. I've been very clear with Mr. Glass and his client about the fact that I don't think this is a precedent that we want to set, but I think with the analysis that's been done, that's where I would be tonight in a recommendation to the board, if that's what you're looking for, Chairman Soto.
That is what I asked for.
Mr. Soto, could I follow up on Dr. Pace? Do you want me to wait till after Mr. Thacker?
Yes, only after I give Mr. Thacker an opportunity.
Very, very quickly, because I'm really ready to vote on this. I understand all the comments made tonight. I am very concerned about the product that it's bringing to Osceola County. I'm very concerned about a flood of these requests we're going to have in the very near future of very similar types of things or things that may not even be similar, but where they feel they're unique and they're going to do something unique that will not have generation rates and ask us to exception that where they escrow it. And I don't want to be a board that spends all their time on every single development on what the exception is on why they're different. But with that, I'm ready to vote on this and move on.
Mr. Cooperbacher.
Yeah, I just wanted to clarify some things, Mr. Chairman. One, I'm not making a recommendation on this. I'm advising you of what the issues are, what the things are. The reason that Tyndall Oliver was comfortable with the alternative is because the foundation of it includes the townhome rate if the data generates it. All right. The lawsuit, I don't want this board to ever blink because somebody says we'll be sued. That's, I mean, anybody can file a suit any day of the week, and the outcome's the outcome. So please don't have that as your driving factor. The one issue, Mr. Thacker, that you bring up is one that we cannot give an answer to. We have tried to limit this as best as possible, but we are completely unable to predict the one-off impact of this. The only thing we know is we're going to have about a 6 or a 9 month window before we have that study back and be ready to look at the new information. In the meantime, if you go with option 2, we'll be seeing what data is generated there. If you decide to vote for option 1, that denial would be based upon a decision that on your consultant's position that it should be the townhome rate.
All right, thank you for clarifying that. I don't see any more hands. And with that, I'm just going to pause to see if I do. Very well. So I do believe that we have a motion by Mr. Weissier and a second by Mr. Booth to approve number 2.
The other way. Motion by Booth, second by Weissier.
Motion by Mr. Booth and a second by Mr. Weissier to approve number 2. Therefore, I'm going to call a roll call on this not because of any other reason, but so I want to go ahead and make sure that the record's correct on the vote for this. All right? I mean, we could all vote right now, but then I'm going to ask who voted.
That's fine.
All right. Okay. So I'm going to go ahead and call on District 1. What say you, aye or nay?
Nay.
Okay. On District 2, I say nay. District 3?
Yes.
Okay, that's a yes. District 4?
Nay.
District 5? District 5?
Only muted.
I was muted, but yes.
Yes. All right. So the vote fails. 3 nays to 2 yay.
So does that automatically mean that option 1 is what we're doing?
I will make a motion to approve option 1. I think, do we need to vote on? I think we need to approve it.
We could do
Yeah,
that.
Mr. Chairman,
Yes, sir.
my understanding is Mr. Thacker, your motion is to deny it based upon the consultant's recommendation that the townhome rate be applied. Am I
Yes.
correct?
That is correct.
Thank you.
That's what I understood. I have a motion to approve by Mr. Thacker. Do I hear a second?
Second.
All right. So we have a motion to approve by Mr. Thacker.
Discussion.
On a second by Ms. Castillo. And I'll go ahead and take discussion on this second one. Please, may I ask that we do not rehash on the other and just talk about this new motion? If possible.
Absolutely.
If possible, but you do what you want. Mr. Weissier, you have.
No. That's perfectly appropriate, Chairman. Thank you. My question really is just to the board. Is there any? You're looking at this as a denial or approval. Is there any nuanced approach that would allow us to revisit this short of a denial and build in language that would more satisfy you for an approval? And instead of voting this down, send it back to the drawing board with legal counsel to address your specific concerns or to strengthen the document and agreement to mitigate those. I'd like to see us, if possible, instead of denying it, work to mitigate what your specific concerns are and bring it back at our next meeting.
Mr.
I didn't know. Was that a question to Mr. Thacker?
It's to all board members.
Okay. Well, Mr. Thacker, go ahead since you begin.
Tim, that's a great question. And and I don't even know if we can do this or not at this point because we have an option 1 and an option 2. I would be fine to approve this with the stipulations I have at the townhome rate right now. Was that
Before, okay, I want to go ahead and so we already had ample discussion and a lot of, keeping bringing it back, it's just really not moving on. So
No, I disagree. I think Tim's asked a good question. Do we have we have an option A and B or 1 and 2, whatever they are?
It is, but we already.
Option C that's somewhere in the middle that we could, if we pass, it's another option for them. My hunch is they've got the same option. If we do an option C, is they do in the option 1. They can go to file a suit or do whatever, or they could accept that.
What I understood was that When you made the motion to approve option one, Mr. Thacker, and you asked for clarification, and it was seconded by Ms. Castillo, there was a clarification asked from the board attorney, and it's basically is that we are accepting the recommended rate of townhomes.
What option one is my understanding is we did the,
I'm going to ask the attorney to
reverse it and do the approval with that recommendation.
Mr. Kuchenbacher, could you once again please explain?
Yeah. I believe Mr. Thacker is doing a good job of trying to clarify the record even better. I think you would have a motion that by denying it's the negative, meaning if you deny the alternative impact fee calculation based upon the consultant's recommendation of townhome rate, then it would be that if they pay the townhome rate, they're good to go. Like any, I mean, if they don't pay the townhome rate, they're not good to go. That's the effect of your motion, Mr. Thacker. And I hear what you're saying is if they pay,
do it.
the board has no objection to it. Well, if they pay the townhome rate, they are able to go.
Ms. Castillo, I'm going to ask you, is that what you understood when you seconded the motion?
Yeah, I thought we were just accepting that Mr. Thacker put forth to accept alternative one. Is that not what just happened?
No, that's okay. So at least I also understand it that way. Mr. Weiser, do you understand something different from that motion?
No, not specifically, but again, it's not, you guys are assuming that the only options we have are vanilla and chocolate. And what I'm saying to you is it does not have to be that. You do not have to take action as a board solely upon what the recommendations before us are. We as a board could create option 3 instead of 1 or 2. And what I'm saying is that if the board had specific issues with number 2 that could be addressed or mitigated, then it would be prudent for us to discuss that as opposed to just automatically reverting over to number 1. If that's not the flavor of the board, then I respect that. I just don't want us to assume that we're boxed in when we're not. We're the board and we have the ability to make whatever decision we want, whether it's presented to us as an option or not.
Very good. Mr. Booth, I see your hand.
Well, I guess my question is, hold on. My question, I guess, was kind of the same as where we started. So if we motion to vote number 1, we're saying we're denying your alternative, and you can build at the townhome rate, and you're good to go. That's correct, right?
Yes.
Okay. And so look, I think the board spoke. I mean, I'm ready to move forward on this issue. The board spoke 3-2. I obviously supported the alternative number 2, even though I don't like it. But actually, where I'm at now is the board spoke. So let's move on with it. If they want to build at the townhome rate, that's what we're prepared to do. I agree with Mr. Weiser. If we wanted to create something different, we absolutely could. He's 100% correct, and I agree with him. But I'm ready to move on with this situation. I think the board spoke. We want to move on, and I would be in favor of saying now, build at the townhome rate, and we'll reassess when we do another impact fee study.
Mr. Thacker.
I'm almost, and I don't know if this is appropriate or not. That is really where I was trying to go, and I was thinking vanilla and chocolate. I would not mind to make it very clear that my problem is not totally conceptual with what they're trying to do with the smaller apartments, but I wouldn't mind doing a strawberry and changing the motion to be an approval with the townhome rate, acceptance of that.
I think that's where we're at, Mr. Thacker.
No, we're denying it. We're saying it's denied.
We're denying the townhome. We're saying that we're denying the townhome rate.
We're denying their study. We're denying, what are the words exactly? And we're denying it based on our consultant's opinion that it should generate or be charged at the townhome rate. But that's not approval at the townhome rate. I don't know if it makes it if they were to come in here today and say, here's the townhome rate, we're all good to go, I don't know that we'd be having this discussion.
You know,
This off at the chase by approving it at that. It's the same thing. It's just a matter of semantics.
If you do not accept Mr. Thacker's correct. If you do not accept the alternative analysis, you are saying you're accepting the consultant's position of applying the townhome rate with no agreement. And if they paid the townhome rate, they would have complied with the ordinances you wanted applied, and they'd be going forward to build or convert.
Thus, this would all be moot.
Yep.
Question, Mr. Chairman, I'm ready to vote.
Yeah, I say, Chairman, I think we've exhausted the conversation.
very well, on item number 1, we have a motion to approve. And by Mr. Thacker, second by Ms. Castillo. All those in favor of accepting, of approving number 1, please state aye. I'll do it again just to make sure. District 1,
Aye.
District 2, aye. District 3,
No.
District 4,
Aye.
District 5.
Aye.
So I believe I have 4 aye votes and 1 nay. Therefore, it passes. The denial of the alternative education impact fee calculation. All right. So I'm pretty sure that future board member meetings and workshops will continue to hash out this. It's always been one of the duties of the school board and the school district. It directly relates with funding, so it definitely gets, a lot of necessary and appropriate attention. I hope that I gave everyone an opportunity and nobody feels that they were not able to express what they felt or ask questions about this. It's a difficult decision, and I'm really proud of how the board really discussed it, and the courtesy that we gave to each other to go ahead and express how we view this item. I don't know. I see 2 hands, and I think if somebody wants to make a final statement on that, I will allow it. I'll go first with Mr. Thacker.
I'm sorry, mine was still up from previous. No comment.
Mr. Booth, is there anything you want to add to my comment or? No? Okay, I don't see no more hands. All right. So with that said, we'll go ahead and move on. We're still in number 14. 1402 is attorney comments. Mr. Cooperbacker, do you want to say?
I just advise the board we're deep into working on healthcare agreements, and we will be coordinating and talking with Mr. Thacker as the board member who's taken the lead, working with us on this, and be coming back to you in the near future regarding that.
Very well. Thank you, Mr. Cooperbacker. We'll go ahead and move on to 15.01, superintendent's update.
Yes, just a reminder, board members, I have requested a short executive session. We do have an update on potential plan designs for our health insurance as it relates to labor negotiations following this board meeting.
Very well. That takes us to 16.01, which is unfinished business. I personally don't have any. Anyone else? I'll go down. District 1.
No.
No. 1, 2, 3.
No, sir.
4.
No, other than, have we been mailed the dial in for the executive session? Is it in our?
Yes.
Okay, I just
It's
looked.
in your email.
Okay, thank you.
Excellent. And District 5.
Nope.
Very well. So then we'll go to new business. Anyone? Seeing none, then we'll go to 18.01. That is the EPG. Correct me if that was Mr. Booth that brought it up.
That's correct. If you don't mind, Mr. Chairman.
You have the floor, sir.
Since we love talking about ordinances tonight, I've actually reviewed this one, just not in depth, but I have reviewed the EPG ordinance. I guess for the public's knowledge, and correct me if I'm wrong, Mr. Krubacher or Dr. Pace, I mean, really these were set up to help with hurricane preparedness and hurricane, what we would do in the event of a hurricane. So certainly they're there for the right reasons. To say I was disappointed with what happened is an understatement, with the ordinance that they set forth, and then with a fine and jail time and whatnot. Extremely misguided and not the way that we should be, not just in Osceola County, but in the United States of America. So with that said, I just, and maybe Mr. Kruppelbacher can answer, and maybe can't answer today. We could just give me some information later to give me a little bit of idea of our role on that, because certainly I don't want to see the school district get caught up in some of these things without a voice. And I mean, the way I understand it is the county essentially has 5 members, and then there's 4 others. So certainly it's essentially whatever the county decides they want to do, and then everybody else. And so I don't want to, you know, and if that's the case, I certainly think this EPG needs some restructuring. I don't know if it's a debate we should have tonight or not. Just some more information of our role.
I can address that for you.
Thank you.
I participate in a group which involves the city attorney in Kissimmee, St. Cloud, myself, the county, maybe the sheriff's department, but I'm more attuned to the others. It has been raised that the committee is not balanced in terms of the voting, because there are 5 county people and the cities don't independently have equal or greater vote. So the discussion to look at addressing that issue going forward, it was basically decided, I believe, or in the emails and that we would literally, now wasn't the time to really get into that. It was like, let's get through the crisis, take care of everybody, and then deal with what we think would be recommendations to our boards regarding that.
Walker, I do appreciate that, and I just want to make sure, you know, as a school board member, that that, you know, it just seems odd that we sit on this EPG, and this is for, and obviously I'll be leaving the school board, but as any school board member sees their position on this EPG and sees that they can pass ordinances which have some teeth as a misdemeanor, as I read in the ordinance. It seems that with no power within that group, that you're just basically attaching the Osceola County School District's name to an ordinance that one other entity has decided, and I just don't think that's the way the EPG is supposed to work. I don't think any EPG across the state should work that way, and I just want to get that out there on the record.
You know, Mr.
I think that was the genesis of our concern as the lawyers, was that what is coming out is something that reflects all of the governments, and it may in fact not reflect all of the governments.
Well, actually, I think if and what was the other concern, if you don't mind, Mr. Chairman, is that it's been very hard, I think, for folks that have been contacting me to find the public information about this. About I had to actually reach out to the member that was there for us that day, which I believe was Chairman, or was Mr. Thacker, and ask him what happened. It seems that the public information about this meeting and how it works has been extremely difficult to get. And actually, once you find out about it, you do realize that all the other entities, I believe, voted against it, or at least all but maybe one. So that has to, I think, give pause to the folks that voted yes. And certainly, I think the community needs to understand that as well.
I should let you know that issue. I believe Mr. Thacker actually may have raised that issue to me, or the vote issue. I know one or the other, but during one of the issues we raised as lawyer going forward was proper notice to this group to comply with the sunshine law.
I appreciate it. I didn't mean to have to get into an in-depth. I just want to make sure that the school board is represented properly within the community.
Now,
certainly on this issue, we were not.
All right, so Mr. Booth, this is still your item, so you can chime in whatever. But what I want to do, I see Mr. Weissire's hands up. Weissire, with your permission, because Dr. Pace's hand is up and she is on the EPG. I want to hear from her first, and then I'll take your comment. Is that fine?
Yes, sir.
Thank you, sir. Dr. Pace, please, you have the
floor. Sir, I appreciate the discussion regarding the executive policy group. It has placed me and Mr. Thacker in a very difficult situation over the last couple of weeks. Typically, the decisions that the EPG is making are more related to operational questions. I believe that's probably why the superintendent is identified as the member of the executive policy group as opposed to the school board chair or a school board member. When I'm not able to attend, I have asked Mr. Thacker to attend as my designee, and then he's able to represent the board and the school district. I will tell you that Mr. Thacker's votes are the same as mine would have been. And while we are continuing to work together, the theme is common, that everybody understands that once the pandemic crisis is over, we do need to revisit the executive policy group as a board, as a functioning operation, and decide and make sure that it fully represents the legal entities, the governmental entities well in this organization when we're having to make hard decisions and policy decisions, perhaps. But more important, my focus has always been the operational decisions as they impact the school board and the school district in times of crisis. So that is definitely something that will be further discussion around as soon as we get past this EPG, this crisis.
Mr. Weissire, you have the floor.
Thank you, Chairman. It sounds like we're all in agreement, or all that have spoken on it anyway are in agreement that the system needs to be reviewed and adjusted. I completely agree with Mr. Booth's comments at the beginning. This is not set up properly. It does not function properly, and it is not adequately represented. And so I'm in full support of bringing together the government agencies to talk through how to adapt this policy group going forward to ensure that all people have an opportunity to weigh in and make decisions around this.
So, Dr. Pace, you have your hand up still? Okay. So, all right, so I don't see any hands up. I want to go ahead and chime in, if I may. And I just think, Mr. Weissire, Dr. Pace, Mr. Booth, board, I just think it's good practice to go ahead and just revisit policies such as an EPG, where you have different organizations that have to work together. As experience dictates, there's just so many more things that can be, so many ideas or policies or processes that could be adopted that could make it a stronger functioning body. So I think that whatever, anybody that's part of the EPG or others that are being affected by these decisions, whatever ideas, whatever they want, concerns, I would be in favor of just a review, a periodic review on this, but I definitely do support Mr. Booth's concerns and the fact that we should revisit it and to see what we've learned can guide us into making it a better policy. Any final words before I move on? Okay, I gave it enough time. There's no hands. So that takes us into final comments from board members. I'm just going to go down the list. Any final words from our District 1?
No, sir. Thank you.
There is none from District 2, District 3.
Sorry, I just want to say good job, Chairman. You did a great job of managing the meeting tonight, and I appreciate your leadership.
Thank you, Mr. Weissire. District 4?
No comments. Thank you.
Thank you, sir. And District 5?
Tim stole my comments, but I think they bear repeating. You did a great job. I know it's extremely difficult to manage this many folks on a web meeting. So good job, Mr. Chairman, and thank you.
Give yourselves credit. You guys are a great group of people. And I tell you why, is that regardless of how we may see things differently in the core, I'm convinced that you four, and of course the superintendent, are just very good people that really care. So once you have that, everything else becomes a little bit easier to go with. With that, I'll go ahead and call this meeting. I don't know if I have to adjourn it for the executive session. I'll go with that.
You're adjourning this meeting.
Very well. Thank you, Mr. Kupenbacher, and I'll see you all in a few moments.
I'll have to go to a